Anayasa Mahkemesi'nin saygıdeğer başkanı.
Distinguished President of the Constitutional Court, distinguished Deputy Presidents, dear guests. Welcome to the second day of our symposium, which we have organized on the occasion of the 60th anniversary of foundation of the Constitutional Court of the Republic of Turkey. The second session will be about international human rights in interpretation of constitutional rights and freedoms. Chairperson will be Mr. Zeki Yiğit, the President of the Council of State, and the panel will be Gianni Bucicchio, Dr. Yaşar Salih Paşaoğlu from Ankara Hacı Bayram Veli University, Faculty of Law, and the senior reporter, Mr. Özgür Duman, the chief rapporteur of the sections of the Constitutional Court, Mr. Özgür Duman.
Oturumu başlatmak üzere.
Now I give the floor to Mr. Zeki Yiğit to moderate the session. You have the floor, Mr. Chairman. Distinguished President of the Constitutional Court, distinguished guests, distinguished participants, I wish you a very good day. And I also would like to salute distinguished international participants who have visited our country from many different countries. And I also would like to congratulate the Constitutional Court on the occasion of the 60th anniversary, and I wish all the best and success to distinguished President and the members of the Constitutional Court. In this panel, we will be talking about the protection of fundamental rights, international human rights law and its effect on interpretation of human rights. We will be listening to 3 papers, each of which will be limited to 15 minutes according to the schedule in front of me, after which we will have a 30-minute Q&A session. And in this part, we will be listening to the paper titled Comparative Constitutional Interpretation as a Tool for Improving Democracy, Protection of Human Rights and Rule of Law, Mr. Gianni Bucicchio, the Special Representative of the Council of Europe, Venice Commission. You have the floor, sir.
I assume that I should speak now because my microphone that didn't work. But first of all, I would like to greet the President of the Constitutional Court of Turkey, the President of the Council of State of Turkey, all the presidents and judges of constitutional courts here present, and ladies and gentlemen, I am pleased to be with you in Ankara and to meet you in person today. The long period of online meetings was a very difficult one. Meeting in person is essential for substantive discussions, not only during the sessions of the conference, but also in between. Let me start by congratulating the Constitutional Court of Turkey on its 60th anniversary. I would like to thank President Zühtü Arslan and all the members of the Constitutional Court for their important work in safeguarding the Constitution and its principles, as well as our common values. You do so in a difficult environment, and it is remarkable that your court continues adopting judgments that protect human rights. At the same time, I'm troubled by some very recent decisions taken by the ordinary jurisdiction in this country. The introduction in 2012 of the individual application to the Constitutional Court of Turkey under Article 148 of the Turkish Constitution was a success, and you uphold this important achievement. In our session of the conference today, we discuss the effect of international human rights law in the interpretation of constitutional rights and freedoms. This topic goes right to the heart of the individual complaint. Article 90 of the Turkish Constitution establishes a system of human rights protection that is very open to international treaties. I cite, in case of a conflict between the laws and international agreements duly put into effect in the field of fundamental rights and freedoms, due to a difference in provisions on the same matter, the provision of the international agreements shall prevail. End of quote. This means that human rights treaties prevail over ordinary Turkish national laws, but not over the Turkish Constitution. This provision of the Constitution is directly applicable, and its hierarchy must be respected not only by judges and prosecutors, but also by the police and any other state official. And it is your task as members of the Constitutional Court to ensure respect for this hierarchy. When we talk about international treaties in the field of fundamental rights and freedoms, alongside the International Covenant on Civil and Political Rights, it is, of course, the European Convention on Human Rights that is the most relevant treaty in this respect. And when we refer to the Convention, we mean the Convention as interpreted by the European Court of Human Rights. The Strasbourg Court gives life to the articles of the Convention and decides with binding force for all parties to the Convention how the articles of the Convention are to be interpreted. When we talk about interpretation in the context of the European Convention on Human Rights, the principle of proportionality is, of course, also a very important interpretation tool. Before we come to proportionality, let me briefly touch upon other interpretation techniques and how they can relate to our topic, also in the light of Article 90 of the Turkish Constitution. In deciding on constitutional matters, notably in the framework of the constitutional complaint, you interpret several texts. Whatever the individual act is that caused the alleged human rights violation, as part of the decision on the individual application, you also have to interpret various legal texts. You interpret the national law, that this is the basis for the act. You interpret the relevant articles of the Turkish Constitution, and under Article 90 of the Turkish Constitution, you do so by taking into account the European Convention on Human Rights. In this exercise of interpreting texts, you will normally start with a literal interpretation. This first method, however, will in many cases not be sufficient to understand the full meaning and reach of a legal text. Often, in addition, the historical interpretation approach will be helpful. This method consists in exploring the manner in which an act was adopted, what the intentions of its authors were, and how the text fits into the constitutional framework and that of the other pre-existing legislation. A systematic interpretation taking into account the whole system of laws surrounding the legal provision under consideration will enrich the interpretative tools of the court and possibly enable it to have recourse to an interpretation by analogy or to reason a contrario. Finally, a teleological interpretation which takes as a starting point the aim pursued by the legal act under analysis will allow the court to interpret it in the manner which best fulfills the original purpose of the normative text in the society. All these techniques are at our disposal, and the judge may apply them either alone or together. Of course, arguing why a specific technique is more appropriate than another in any given case. These techniques refer to the interpretation of the text, but they do not yet relate to the result of the examination of the case by the constitutional judge. There is another, finer tool which has the advantage of avoiding the necessity of annulling a text which is found to be ambiguous, as unfortunately is often the case. Indeed, it may happen that the aforementioned techniques reveal that there is more than one possible interpretation, one being in conformity with the Constitution and the other not. In such cases, the constitutional judge may decide that the interpretation which is in conformity with the Constitution must be applied by all the state bodies. We can describe this method as the power to ensure constitutionality through a specific interpretation. In this concept, we see elements of the presumption of constitutionality and the so-called double construction rule, as the Irish lawyers put it, or réserve d'interprétation in French. However, there can be serious drawbacks when the correct constitutional interpretation given by the Constitutional Court is not followed in practice by the other courts and states bodies. And unfortunately, this happens often enough. Conversely, and in order to overcome this problem, the Constitutional Court can invalidate a legal provision if it is consistently interpreted by the ordinary courts in an unconstitutional manner. This means that the legislator must adopt a new legal provision which hopefully follows the correct constitutional interpretation and thus ends the previous unconstitutional interpretation of the law. Mr. President, let me come back to the technique widely used by the European Court of Human Rights and many other constitutional courts, notably the Federal Constitutional Court of Germany, which developed it. With a few exceptions, for instance, torture, which remains strictly prohibited in all cases, most human rights allow for some limitations. In the European Convention on Human Rights, references to these limitations are typically found in the second paragraph of the relevant articles. Rights that may be limited are inter alia the right to liberty, fair trial, the freedom of expression, freedom of assembly, and so on. However, to what extent may these rights be limited? Here, the principle of proportionality comes into play and provides important guidance. Where the case concerns a negative obligation, the European Court of Human Rights usually assesses a series of questions to determine whether an interference in a right was justified under the Convention. Is the interference in accordance with the law? Was the interference in pursuit of a legitimate aim? And is it necessary in a democratic society? Thus, these limitations must be made for legitimate reasons that do not constitute a disproportionate and unreasonable interference with the aim pursued, undermining the very substance of that right. To take only a few examples, the right to freedom of assembly is not absolute. It may be subject to restrictions in accordance with paragraph 2 of Article 11 of the Convention. However, any interference with the exercise of that right must be necessary in a democratic society. An interference will constitute a breach of Article 11 unless it was prescribed by law, pursued one or more legitimate aims, and was necessary in a democratic society for the achievement of those aims. The proportionality test is also critical for the prohibition or dissolution of political parties, which is a very far-reaching measure that should be used with the utmost restraint. The European Court of Human Rights takes into account whether there is a risk of democratic principles being undermined and whether this establishes a pressing social need. The Strasbourg Court takes into account the following points: whether there was plausible evidence that the risk to democracy was sufficiently imminent, whether the party's leaders' acts and speeches taken into consideration in the case under review were imputable to the political party concerned, and whether the acts and speeches imputable to the political party formed a whole which gave a clear picture of a model of society conceived and advocated by the party, which was incompatible with the concept of democratic society. Ladies and gentlemen, recently in a number of European countries we have encountered problems with a wide interpretation of emergency powers in the context of the COVID pandemic. Constitutional courts and equivalent bodies all over the world had to rein in excessive interpretations of emergency powers of the executive powers. The state's margin of appreciation in times of emergency is indeed larger than during normal times. This was particularly true in the situation where information about the virus and the most efficient ways of combating it was scarce or uncertain. However, a larger margin of appreciation cannot make judicial review meaningless, and as we have seen, your constitutional courts took that control very seriously. Mr. President, let me conclude that constitutional interpretation is a wide field. Traditional techniques of interpretation apply alongside specific techniques required for determining the scope of possible limitations to human rights. In this respect, the principle of proportionality, which is indeed an interpretation technique, has a central role to play. It is up to you, the members and judges of the constitutional courts, to choose in each case the appropriate techniques of interpretation and to interpret the applicable text. Notably, in the framework of deciding on individual applications, it is upon you to decide which limitations to human rights are acceptable. In this choice, you are guided by the values of the Constitution, by the principles of democracy, the protection of human rights, and rule of law. Dear members of the Constitutional Court of Turkey, you have given an oath to defend the Constitution of the Republic of Turkey and fundamental rights and freedoms, and to abide by the understanding of the law in accordance with the fundamental principles upon which the Constitution is based, to the best of your conscience and without being prejudiced by any influence and concern whatsoever. I trust you to honor this oath. Thank you very much for your attention.
We would like to thank Mr. Bokekü for his presentation, and also I would like to thank him for abiding by the time limitations very well. And the second speaker of this session is Dr. Yaşar Salih Paşaoğlu, Professor Salih Paşaoğlu from Ankara Hacı Bayram Veli University, Faculty of Law, from Department of General Public Law, and his paper is about an evaluation of the application of Article 90 of the Constitution in the law of proceedings. Thank you, Mr. Chairman. First of all, I would like to extend my gratitude to Turkish Constitutional Court for inviting me to this symposium, and also for accepting my paper in the publication which has been published on the occasion of the 60th anniversary. I am going to talk about Article 90 of Turkish Constitution. We will take a closer look at this article, and we will evaluate and we will dwell on its repercussions on law of proceedings. As you know, it's about international conventions and treaties, and in 1961 Constitution, it existed and it was verbatim translated to the 1982 Constitution. And it says, as a summary, the international agreements duly adopted are as powerful as the national legislation, and they are binding for Turkish law. And based on this arrangement, actually it reflects the international relations concept which was formed after the Second World War. And based on this concept, the interpretations are being made based on the fundamental rights and liberties, but basically there are three different approaches in terms of interpretation. The first one is the one which sees the international agreements equally with the national law. The second approach is that it is higher than national laws. And thirdly, if these agreements are about fundamental rights and liberties, they are even higher than the Constitution, or at least equal with the Constitution. In 2004, there was an amendment, and there was a new provision about international conventions as to fundamental rights and freedoms. And it says, if it is about fundamental rights and freedoms, and if it contradicts with the national law, it's going to be superior to national law. But it did not end the controversy. It did not end the dispute. Within the framework of this amendment, more people started to support the idea that the international conventions as to fundamental rights and liberties is superior to Turkish Constitution. So it actually solved the problem as to which one would apply if there is a contradiction. So according to Turkish Constitution, if there is an international if there is an international convention or agreement duly adopted and put into place, then it's going to be taken as basis. When we take a closer look, there are three conditions stipulated here. The first one being, the international agreement should be about fundamental rights and liberties. Secondly, it should be duly adopted and put into practice. And the third one is a contradiction with the national law. About the first condition, the terminology used in the Constitution is fundamental rights and liberties, but some people suggest that it is missing because in 5 places in our Constitution, the human rights terminology is used. But in this one, it is not used. The second condition, the second terminology is the international agreements, because some are conventions, some are protocols, some are charters, some are pacts. So there are lots of regulating text with these titles, but as per our constitution, it only refers to international agreements. But in practice, they don't mean anything. If there is anything regarding fundamental rights and liberties, any convention, any agreement, any treaty are considered the same. So it's just a theoretical discussion and dispute, so it doesn't make any sense. And what about the scope of these agreements, these conventions? First, the United Nations and Council of Europe conventions and agreements, but not limited to them. There are innumerable international conventions, and they have become an integral part of our domestic law with this provision. So we don't know how many there are. There are so many. There are too many. And they contain so many provisions, but they are now a part of our domestic law. What does it mean for us? We will talk about this, but this is an important topic. And one of the most important ones is there is a need to limit these agreements, maybe in terms of their source or origin, or in terms of their quality or nature. There must be a limit, otherwise it's going to be a mess. And for the executive power, it's going to create trouble and difficulty in terms of identifying which method to follow. But as of today, this is the picture we have in front of the judges. We have these international agreements, conventions, too many, and containing too many provisions in them. It's actually so important, and in practice, this article applies very often. However, in legal education at the universities or in-service education and training, we cannot say that we are rendering this education at a high quality. So most of the practitioners do not know so well about international agreements. Of course, there is a lack of knowledge and resource in terms of the UN or Council of Europe agreements. When we look at the court decisions, most of them refer to the European Human Rights Convention only. However, there are so many others, but they are not referred. This shows us that there is a lack of knowledge and information among our judges. And secondly, the second condition about implementation and taking effect of an international agreement. Actually, it has been stipulated according to many domestic laws. Currently, the Presidential Decree number 9 regulates how these international agreements are going to be implemented. There is no problem about it. But the third condition tells us that there needs to be a contradiction between the international convention and the national law in terms of fundamental rights and liberties. So here, the main point to note is the terminology law. What does the Constitution mean by law? Because we are telling about a contradiction between the international convention and national law. we understand that what is meant by law is the norms which are hierarchically equal to laws. So, Constitution is not a law. And today, we are talking about regulations or bylaws. We are not publishing bylaws anymore, but there are lots of bylaws which are still operational. And they are excluded from the scope of this article. So, international agreements have the power equal to a law. And if there is a regulation or bylaw which contradicts with the law, definitely the law will prevail. And what about the contradiction between an international convention and presidential decree? I don't believe that there is a problem about this. Constitutional article number 104 says that if there is a contradiction between the law and the presidential decree, the law prevails. And law means international convention. So the international convention will prevail. This is very obvious according to our constitution. And what do we mean by the contradiction? There are two approaches, the differences between the law and the constitution. Just as the case in the norms, maybe the laws have different provisions. It can be a partial or obvious contradiction. For example, Article 5 of European Convention on Human Rights. There can be a provision in the law of proceedings regarding to security and freedoms. Or let us assume that divorce is a human right according to European law. However, according to the European Convention on Human Rights, marriage is a right. However, divorce is not explicitly considered as a human right, but marriage includes divorce as well. But we can talk about a contradiction here, or in the Convention on combating discrimination against women. And if there is an inequality in the law between men and women, we can talk about a contradiction. And about the children, those under 18 are considered to be minors, considered to be children. But if a law precipitates that, specifies that, for example, 16-year-old or 14-year-old person is an adult, this is a contradiction. Actually, the interpretation of the review organs of the conventions should be taken into consideration. This is also suggested by others, and actually these kind of review or control mechanisms are put into our system. In Turkey, when we look at the practice, we see that the judiciary in Turkey is a little bit confused. When we categorize the decisions, we can see three different approaches. And the first practice, which is one of the most common ones, according to Article 90 of the Constitution, the references are made to here, but there is no explanation about which provision of the domestic law is contradicting with the international law, and the problem is solved according to the law.
I want to give an example about this. For example, the Fourth Department of the Court of Cassation implements this method for compensation cases they are making a reference to the Article 90 of the Constitution, and they say that the internal law and international conventions, international agreements should be taken into account together. Actually, this is a little bit contradictory. The Court of Cassation made a decision about the surname, and these are not actually are implemented together. We need to have a conflict to make a selection among them, and we should select international treaties or agreements. And then talks about, gives us example about the European Court of Human Rights decisions. So they base this on 3 stages, and they talk about these 3 stages for pages and make references to hundreds of decisions of the ECIHR, and then they resolve this issue based on the 15th article of the Civil Code. They say that yes, there may be a compensation, but the amount is too high. So there is another practice. This is not widely frequently seen, but it is more overlapping with the purpose of the Constitution. There is a reference to the 19th article again, and then they talk about, they give an example of an international treaty, international agreement, which says a totally different thing, and then resolve this issue based on this another international agreement. So this is more overlapping with the purpose of the Constitution, and there is also another agreement of UN for the transboundary crimes, and for this crime to be committed, it requires 3 or more. In our law, it is 2 or more, 2 people or more. And in an example decision, they talk about this contradiction and make a reference to the law and implements the Constitution. So this is a different practice, and this is more suitable with the purpose of the Constitution. There is another example. There is another, again, they make a reference to the Article 90. And they talk about the internal norm contradicting with the Constitution, and then list all the decisions of the controlling body for this international organ, international agreement, and they also list internal law, some decisions from the European Union countries, and then the issue is resolved based on the interpretation of the controlling body. There are examples of these kind of decisions, but of course there is a difference between the Constitutional Court making a decision about that and the Court of Cassation making a decision about that. The Constitutional Court is making a different decision. It is basing its decision on human rights. And there is also an independent application to the Constitutional Court. For example, we have a decision about the surname law. The women can use now their own surnames before they get married. They can use their maiden names. And but normally in our law, it is stated that the women, when they are married, they receive their husband's surname. But it is the first one of the departments says that this is against international agreements, and the second department says that it is not. And then they make a decision, and they make an evaluation about that, and they base this decision on the 8th article of the European Declaration of Human Rights, the European Convention on Human Rights, and they talk about also the case law about the private life, and they also involve the surname in the private life, and they, as I said, focus on the Article 8 of the European Convention on Human Rights, and they resolve this issue in this way. But there is a problem here in terms of the protection of the human rights. We are talking about a more comprehensive approach for the protection of human rights. But there is another issue. There is a question mark on my mind if it is in compliance with the Constitution, because in the law, in Constitution, we know that if there is a conflict between the law international agreement and the local law, domestic law, the international law, international agreement prevails. Yes, but we need a conflict. We use the international agreement when there is a conflict or the decisions by their controlling organs, by the controlling organs of these international agreements. About this approach, I have some question marks about this surname decision. The European Court of Human Rights is not actually deeming his decisions binding. If it would be like that, there will be some pilot decisions. They is just making some decisions about some pilot decisions, and they want the party state to resolve this issue. And it brings this binding, brings some issues, some problems too, and it is not also sustainable. If they have objective binding, if they're objectively binding, then there is a decision made recently about the Turkish Penal Code about the president of Turkey, and they say that this problem, this issue is actually a little bit problematic about the defamation cases filed by the presidency. And then, for example, in some countries, homosexual marriages are also regarded as families. But if it is binding, objectively binding, then this will be the case for the internal law for Turkey too. Is this sustainable? No, it is not. It is actually hurting the purpose of the Article 90. What is the problem here? Sometimes the Article 90 will be implemented, sometimes it will not, sometimes we will use the norm, and sometimes we will implement the decisions by the court. So this brings together some serious risks in terms of trust. So finally, I can say that this paragraph added to the Article 90 is really important for those who are defending the human rights. Everyone was really happy. But when we look at the if we attach more than necessary value to the final paragraph of the Article 90, may harm the Article 90, and it may cause for us not to be able to implement its own purpose correctly. So when we are implementing the Article 90, we should not exceed the threshold, exceed the limits of this paragraph, this law. Thank you very much. Probably I have exceeded my time, which is allocated for me. We would like to thank you, Mr. Salih Paşaoğlu. We have exceeded the time, but we gave you a few more minutes, but we would like to thank you very much. And we will have another presentation, the third presentation, from Özgür Duman. He is the chief rapporteur of the sections of the Constitutional Court, and he will be talking about the doctrine of non-fourth degree and its reflections from the window of international law and comparative law. Thank you very much. First of all, I would like to extend my gratitude to you all, and it's been a great pleasure for me. You talked about the title of my speech. I will be talking about the doctrine of non-fourth degree and its reflection from the perspective of international law and comparative law. I will focus on the purpose of individual application, and the sole purpose of the constitutional complaint or individual application ensure the protection of fundamental rights and freedoms. Actually, this is the most important purpose of that, and the justification of the constitution is composed of two elements, as you can see in the slide. The first objective is to reduce the number of lawsuits and violation decisions to be filed against Turkey before the ECIHR, and raising standards on rights and the rule of law through the establishment of a well-functioning individual application system. So this is the rationale for the Constitutional Court for the individual application. Yesterday, the President of the Constitutional Court talked about that this is a mission which is undertaken with this new new role and responsibility. They're trying to focus on protection of the freedoms and fundamental rights here. There are two aspects here, two important issues here. It's been almost 10 years, and there are some changes, some approaches, different approaches. Some say that they are number of they are making the court is not fully fulfilling its responsibility, and in this regard, I can say that this doctrine can be discussed. You can see the statistics in the slide. As you can see, the number of applications that Constitutional Court found inadmissible within the scope of the right to a fair trial was about 55,000, and it is a number of applications that weren't found to be related to any procedural guarantee of the right to a fair trial was 44,000, about 80%. On the other hand, within the scope of the right to a fair trial, the number of decisions in violation by applying the arbitrariness criterion was 11 in total, as I can say. So in total of 400,000 applications, we're talking about 11 in total. As of the end of March 2022. There are other individual application systems, and I would like to make some comparative law examples. And and then I will continue with the European Court of Human Rights. And there is an application of the Federal German Constitutional Court. It was established in 1950s, and it is established after the Second World War II, and it doesn't have the legacy of the Nazis. For this reason, people trust this institution, and they tried to find some formula to limit their own judicial responsibilities. We had to have the Heck formula. Heck formula was used in Elfes decision in 1957, and Heck summarizes this formula in this way: if a court decision subject to a constitutional complaint a court decision subject to a constitutional complaint may not be audited in its entirety, but only limited to whether there is a violation in the context of constitutional law. This is called Heck formula, and then there is the patent decision by the Federal Constitutional Court, and the two things are highlighted here. While the decisions of the court are interpreted, the norms, constitutional norms, should be considered by the courts. The constitutional norms, while interpreting the provisions of the law, should be considered, and otherwise, such a judicial decision may be subject to constitutional complaint. This is important. That misjudgments cannot be inspected without limits in all cases, and that the Constitutional Court can intervene only if there is a specific violation of a constitutional right. Of course, this is also debated, and currently, nowadays, Schuman formula is implemented. Schuman is a professor, and he coined with this formula in his doctorate dissertation. And there is an interesting interpretation by the Constitutional Court, German Constitutional Courts. So it says that court decisions that are subject of a constitutional complaint should be considered as laws, and court decisions should be audited in the same way as the constitutionality of laws within the framework of norm review. So this formula was implemented in a decision in 2008, as you can see. I want to give an example of a recent decision. This was made in July the 1st, 2021. In the administrative court, there is a refusal of an Afghan citizen's asylum request. There is a court case, and there is a applicant says that the judge should be changed because in other court hearings, this judge had some Islamophobic discourse, but the dismissal of judge is requested to dismiss on the grounds that he used Islamophobic expression in another decision, but violation due to the arbitrary interpretation of 101 and 1 paragraph sentences of the Constitution is the decision of the Constitutional Court. This is a recent decision, so they make an interpretation about this topic, and they say that despite the fact that these Islamophobic discourses, this refusal, the dismissal of the judge's refusal is called arbitrary. So before finishing this part, I want to say one more thing. As mentioned before, this is not just something about an intervention to the fundamental rights or freedoms. Sometimes this criteria is used, this arbitrary interpretation or arbitrary criteria is used. And if there is a mistake by the court, it is not accepted, it cannot be accepted in a rule or law. So the Constitutional Court says that the final decision about the interpretation of the Constitution is belongs to the Constitutional Court. And thirdly, even if there is not an intervention, direct intervention to the human rights, the arbitrary decisions cannot happen in a rule of law. Let's continue with the Spanish Constitutional Court. This was established in 1970s, and with the constitutional complaint in Spain known as amparo, it was started to be used. An application can be made against the decisions of the judicial organs, as well as the actions of the legislative and executive powers. The Spanish Constitutional Court says that the court decisions cannot be arbitrary in no way, and they should not contain an obvious error. This is the decision of Spanish Constitutional Court, and it says that it should be taken into account that the application of the provisions of the law with a methodological approach that reminds us of the values that activate values that are alien to our constitutional system should be rejected from a constitutional point of view. There is a decision about this. The case of Guatemalan embassy. In the decision, the jurisdiction of the Spanish criminal courts in terms of place was discussed. It was expressed that the Constitutional Court, as a guarantor of the right to effective application, was tasked with examining the reasons and arguments that formed the basis for a judicial decision or prevented a decision on the merits. Here we have actually, there was a speech by the president of Spanish Constitutional Court in the previous symposiums like that. He said that the court noted that this was not the only responsibility to replace the function of the judges and courts to interpret rules of law. And finally, I want to talk about European Court of human rights, and this was an important issue. And during the preparatory studies of the convention, there was a question asked. Can decisions of a state's ordinary court, subject to appellate review, be brought before the body of international assurance? Tate can answers this question. A judicial decision can only be brought before this object collective protection mechanism if the rights and guarantees foreseen by the convention are violated. So it was expressed that if it is quite clear that a decision is not logical, we can call this arbitrary, and this can be a topic of application. I want to underline one thing here. Turkey contributed for the drafting of the European Convention on Human Rights. Turkey is one of the founding founding states of the Council of Europe, and we personally contributed to the drafting of the European Convention on Human Rights. And after this discussion, the 6th article of the convention was formed. And the 4th degree is an important issue. The Article 9, ex-Germany, in 1955, the concept started to be used. The concept of 4th degree is not clearly expressed in the convention, and council bodies not use this concept. The ACHR has started to implement the doctrine of the non-4th degree from its very first decisions. In Schenck Switzerland decision, as it was stated, clearly unlogical decisions can be a topic of this issue. What is the rationale of this doctrine? It is not possible for an international authority to make such a control, and we are obliged to use resources effectively. The legitimacy is another issue, and more advantageous position of the national authorities and development of legal culture at national level. These are the justification of the doctrine, and you can see the limits of the doctrine. The interpretation of the enforcement of the convention is really important, and it says that making the final interpretation is in their disposal, their responsibility, and in other cases, decisions that disregard justice within the scope of the right to fair trial is also a limit to the doctrine. So where did this concept come from? And it is actually a decision related to the Golder and versus United Kingdom. According to the convention, this convention should be considered accordant with the Vienna Convention, and should be noted that the denial of justice is prohibited. When the convention is interpreted according to the general rules of law recognized by modern nations according to the Vienna Convention, it should be noted that the denial of justice is prohibited. So this is one of the first decisions in Garcia Ruiz and Spain, and Perez versus France decisions. They said that there was no violation. I would like to talk about one or two other decisions about the implementation of the European Court of Human Rights. We have Hamidov Russia decision, as you can see on this slide. During the war between Russia and Chechnya, this dismissal of the applicant's claim for compensation on the grounds that it was not proven in the event that the applicant's real estate was occupied by the security forces during the operations of Chechnya, and the real estate was not evacuated despite the judicial decisions. It is decided as a violation. but the compensation cases are refused because they said that it is not proven. European Court of Human Rights says that this is already accepted by the court decisions. This real estate is occupied, and they are not able to utilize their own use their own real estate, and refusal of this compensation is turning a blind eye to justice, and then it is a violation. As you can see on in the slide, in the previous decisions, it is quite dramatic. These are they say that these are arbitrary decisions. And there is another example, Andelkovic versus Serbia. This is about a business problem. A violation of Article 6 can be decided in cases where the national courts have clearly misapplied the relevant law. In a particular case, the law is applied by the courts in a way that leads to arbitrary results or the denial of justice. The applicant wants to have the right to vacation. And there were other examples too, like Boshan versus Ukraine, Serrano versus Spain, and Carmel versus Malta. I want to talk about Carmel Saliba versus Malta. There is a theft, and the only objective evidence regarding the robbery in a law case is that the applicant had access to the residence, yet compensation was awarded. So this is the only evidence. This is an arbitrary decision. So this is the violation of the Article 6 of the Convention. We have Turkey, Balıktaş Bingöl versus Turkey. One of them is decided as a violation, and the other one is decided as not a violation. And in Turkey, there should be an email notification, and they failed to apply the law and the 54th and first paragraph of the 54th article during the decision correction phase. So this is again an arbitrary decision. How the Constitutional Court implements this? It is quite similar to AHİM ECHR implementation. This is not actually a fourth degree assessment, evaluation. The interpretation of the law is important. The court, there's an example, for the construction and trade company. The court reached the conclusion of a violation by discussing the effects of the interpretation of the legal rules on the interference with the fundamental right in question within the scope of the constitutional guarantees. You can see the other examples of decisions for clearly arbitrary or obvious error of appreciation criterion. I don't want to talk about the details of them. Recently, Constitutional Court is implementing a formula within the scope of the right to fair trial. There are many guarantees like independent, unbiased courts, and access to right to access to the court. There are many rights. What is the objective of these guarantees? Actually, it is trying to prevent arbitrary decisions. It is for these guarantees of procedure are aimed at this. So when there is this interpretation which is making these guarantees of procedure meaningless, they make an arbitrary violation. You can see the different decisions, Kenan Österiş and Mehmet Geçgel decisions. And one of these cases was about lawyer who was removed from his post, and he filed a court case, and this was cancelled. This decision was cancelled because there is a provision in the law, in the decree, which states that this person cannot be hired again in public services. So Constitutional Court says that this employment concept is quite clear, and the interpretation of the court is regarded arbitrary and make a decision. As I mentioned before, the number of this kind of decisions is really low. This criteria is a really high threshold, and as in the cases of European Court of Human Rights and the Constitutional Court, in which situations we can implement them. And we talked about examples from the Constitutional Court. It should not be based on an interpretation. There should not be any connection between the evidence and the case. There was one of the examples about Malta, and it was something like that. And arbitrary negligence of the evidence, arbitrary denial of an undoubted evidence when it proves a particular matter. And finally, this is actually a tension area, because that an issue is brought to the Constitutional Court or the European Court of Human Rights. But we need to understand the limitations of these courts. This is not something hierarchical. This is cooperation, collaboration, mutual cooperation, and it's really important in terms of protection of the fundamental rights and freedoms. Thank you very much for your attention. I would like to thank you very much for your presentation. Now we have finished all presentations in this session. I want to summarize these presentations. Bukikyo talked about the international human rights law and talked about comparative constitutional approaches. He talked about teleological interpretations and systematic interpretation methods. The interpretation of the European Court of Human Rights was mentioned, and he also talked about the Strasbourg Court, and it gives life to the convention, he said. And the proportionality was another topic he dwelt upon, and he provided detailed information about this. Professor Salih Paşaoğlu talked about Article 90 and its implementation in Turkey. We focused on the Article 90 of the Turkish Constitution, and he talked about the norm hierarchy in terms of international agreements, treaties. And he said that the provisions of the international agreements prevails the domestic law when there is a conflict. And the implementation, the agreements should be duly put into force in order to prevail over the national law. And in case of a conflict with law, the international agreements are implemented. He underlined that. And in this hierarchy, we can say that constitution sometimes prevails. And finally, Mr. Duman talked about the fourth degree. In 2010, he said the European Constitutional Court, Turkish Constitutional Court, had the new responsibility of individual applications, and he talked about the fourth degree, doctrine of non-fourth degree, and he gave some examples from Germany, Spain, and European Court of Human Rights. He talked about the content and the scope of the control they do. And he talked about the controlling authority of the ECHR. And if the courts made a decision outside the convention, then it is not within the scope of the convention. It talked about the individual application to constitutional court, and he said that it's non-fourth degree, the doctrine of non-fourth degree. So now we will have the question and answers part of this session. When you ask your questions, please introduce yourself, tell your name, your country and your duty, and please tell the name of the panelists you ask your question to.
My name is Khalid Talahmi. I am member of Palestinian Constitutional Court. Thank you for the excellent presentation. I have very short questions for Dr. Yasar. What is the legal status of international human rights agreement under Turkish legal system? Are they in the rank of Turkish national laws, or higher or above, and when they are get effective? Thank you.
Teşekkür ederim. Öncelikle şu
Thank you very much. When our chair was summarizing our presentations, of course, well, I would like to reiterate that I don't think that the international conventions are above our national laws and constitutional law. But of course, we need to talk about the relationship between those two. And in the Turkish judiciary system, especially for the fundamental rights and liberties, if there is a conflict between the conventions and the national legislation, of course, we are going to be abiding by the international conventions. But if there is a conflict, of course, we need to resolve the conflict between the convention and the national legislation. We are talking about lex posterior, lex specialis, lex superior. Of course, the Constitution will bring forth the solution itself. Sometimes there might be some conflict between the national law and the constitutional law. Of course, we cannot say that one is superior to another because we cannot really talk about the hierarchy. When there is a conflict, then you have to resolve it. And when we talk about the international conventions, if there is a conflict between the international convention and the national law, of course, we need to talk about the civic law of 187. And of course, people do have their surnames. What do we understand from annulment. Well, how do we talk about annulment? And the other problem is that when we talk about the rulings of the court and the international court's rulings, of course they are helping us in order to resolve the conflict. If of course sometimes the national law may be in conflict with the international law, with the international convention. Of course, we are referring to the international conventions and the rulings of the international courts. So we make use of them in order to solve this problem. Ayhan Kılıç. I'm the rapporteur of the Constitutional Court of Turkey. I would like to ask this question to Mr. Yaşar. Mr. Yaşar, you talked about international organizations and international conventions in terms of the 19th article of the Constitution. Who will interpret the international conventions? This is the question. And who will we take into account the interpretation of whom? For instance, in the European Human Rights Convention, for instance, how are we going to interpret the rulings of the ECHR or other rulings? Therefore, the interpretation of the rulings are quite important. The ECHR rulings are going to be taken into consideration, or the Turkish court's decisions will be taken into consideration. Will we have this right to interpret our own rulings? Because sometimes you might say, okay, our interpretation is right, we don't accept your interpretation. So I think this will annul the system of conventions. So what do you think about this? First of all, as I have mentioned before, first of all, in our constitutional system, the fundamental rights and the liberties are guaranteed by the international conventions. And we accept them as law. And of course, ECHR is interpreting different cases, and this is binding for us. But of course, there might be some objectivity here, and when there is a conflict with our own legislation, and if we refer to the rulings of the ECHR, this is just like a helping decision, or we refer to those decisions in order to solve this conflict. But here, which authority will be interpreting? Is it going to be the Turkish courts, Constitutional Court, or the ECHR? This is not a problem, because in Turkey, when we talk about the Supreme Court and the Constitutional Court, Constitutional Court's rulings are the same with the ECHR. We have watchdog, for instance, the term watchdog, or the chilling effect, or when we talk about fair balance between the individual rights and the public safety. Of course, we do it with the Court of Cassation, Council of State, and we have not yet encountered with a huge problem that is contradicting the rulings of the ECHR. And therefore, the rulings of the ECHR are very important, but in terms of a time of conflict, when there is negligence of the law, it becomes more important. Thank you very much.
Teşekkür ederim.
Thank you very much, Muharrem İrankoç, rapporteur of the Constitutional Court. I will just ask another question to Mr. Yaşar. from Ayhan's question, in terms of fundamental rights and international conventions, we have the United Nations conventions, but these texts are not directly implementable. Actually, with the conventions, of course, we need to talk about the main texts of the conventions. We are not talking about the conflict between the courts. We are sometimes talking about the texts which are contradicting the national legislation. Because when we just approve an international convention, this becomes a law. But you might revoke this law by just amending it, or by just legislating another law. And I would like to give you an example. For instance, in international conventions, there is a contemporary discussion that we might just get out of any convention with a decree. So it is about this. It is about the separation of powers in Turkey.
As you have explained, the decisions of European Court of Human Rights, there are two issues here. The first one is about general implementation. So we can say that the court decisions are not so suitable for general implementation. And the question is, do you believe that there is a problem about withdrawing from international conventions? Who has the right, the executive or the legislative? We should not get confused. First, regarding fundamental rights and liberties, why are we limiting ourselves only to European Convention of Human Rights? There are 9 dedicated UN Human Rights Convention. In Council of Europe, we have 6 or 7, and there are hundreds of human rights conventions international, and there are lots of provisions that can be implemented. So the only thing that comes to our mind is the European Convention on Human Rights, about fair trial. There are lots of provisions in lots of the conventions. But we want this. If we want to implement it completely, entirely, and also if we take into consideration the interpretations, if you say that you are going to implement everything, then I gave an example. Article 299, insult to the president. And it's very widely discussed, and there are hundreds of applications waiting to be reviewed in European Court of Human Rights. So European Court of Human Rights concluded that this is against freedom of expression. But should we say that with this decision of the European Court of Human Rights, we are just cancelling Article 299 of Turkish penal law? No, of course, it's not a correct approach to give such a role to European Court of Human Rights to solve all the problems of Turkey. No, if there is a contradiction, then we can look at it. But if we want to solve all the human rights problems with European Court of Human Rights decisions, then we cannot do it. There are tens of similar examples that do not come to our mind now. It's just an helping source. And also about withdrawal from withdrawal from international conventions. This was really debated in Turkey regarding withdrawal from the Istanbul Convention. In 1963, a legislation was adopted. With the law, this authority was given to the cabinet, but then with the presidential decree number 9, this authority, this power was given to the president. So we say that it is within the presidential power to withdraw from an international convention. And when we evaluate it from the perspective of positive law, we are going to review whether this practice is in line with the decree. Currently, this decision is in front of the State Council, and administratively it is correct. There is no problem. And also there is going to be another review about constitutionality of this decree. Now the Constitutional Court is going to give this decision. Is there any other question? Please pass the microphone. My name is Akif Yıldırım. I'm a rapporteur in the Constitutional Court. My question is to Özgür Bey, to the chief reporter. In his presentation, he said that he talked about the free trial safeguards and they became meaningless. My question is this: the obvious interpretation mistake. There was a practice of our Constitutional Court, but there was also a case law. So the question is, regarding the result of the trial, sorry, the question is not understandable for us. With your permission, thank you very much for the question. You have given us the opportunity to explain the topic better. We are talking about 3 examples. In all of the 3 examples, the same conclusion was drawn. What was the conclusion? When drawing the borders of not being 4th degree, the court says that if there is an intervention in a fundamental right or liberty, in such kind of interventions, there is the power in Constitutional Court to review the decisions of the first instance courts. Yes, the interpretation is the power of the courts. However, the Constitutional Court of European Court of Human Rights have the right to review this interpretation. And we see that there is such a path followed. In the past, European Court of Human Rights were reviewing whether the court decisions were in line with the principles. But in recent times, European Court of Human Rights started to review the processes as well. And European Court of Human Rights say these are the principles. So these principles, the European Court of Human Rights is going to make a review whether these principles are followed and respected by the first instance courts. So the European Court of Human Rights says that they check whether the regular court followed these principles. Interpretation of legal rules are interpreted by the courts. But if there is an arbitrary interpretation or if there is an obvious mistake, then it is reviewed by the Constitutional Court or the European Court of Human Rights. So, as an exception, that interpretation can also be reviewed. So, normally the Constitutional Court look at the form, and also whether that law is in line with the safeguards in the Constitution. But the interpretation is also reviewed by the Constitutional Court or the European Court of Human Rights. And in Aliyeva and others versus Azerbaijan, the European Court of Human Rights said it was an arbitrary decision, so it was against the principles. The other thing is this. There are also applications regarding the violation of fair trial. We know that the fair trial does not have a result guarantee. So some authors say that the right to free trial should be translated into our own language as not fair trial but as honest trial. Actually, as the Constitutional Court says, this right brings guarantee for many procedures, and this is about avoiding arbitrary interpretations. You say that, for example, the witness says that the person is not involved in this, or this is not covered by the scope of this article. So, if there is an interpretation in the court which is not looking at the witness testimonies or other evidences, so this is making the procedural safeguards meaningful, and this is not a principle of rule of law. And Turkish Constitutional Court makes the same interpretation. So this is all about the principle of rule of law. What is interesting here is actually in each and every example, in each and every case, the same conclusion was made, the same the result was made. And I believe that the interpretation of all the courts are heading for the same place, and they are going to end up in the same place. So there are only 11 decisions when we look at the application. Only 2 or 3 of them are the recent ones. So in a case where the procedure safeguards get meaningless, there is an violation.
Would you like to just ask another question? I think there is none. And I will, first of all, thank all the panelists and also the participants who have asked questions. I would like to thank them all. And I like to thank the participants who have stayed here and listened to us carefully. And I hope that this symposium will contribute to our judiciary system, to the Constitutional Court, and to all our courts. And thank you very much once again. We would like to thank Mr. Zeki Yiğit, our chairperson. We will just present plaques to our esteemed panelists, and I'd like to invite the President of the Constitutional Court, Zühtü Aslan, to the floor.
So, Mr. President, you.
Sayın Başkanım, değerli konuklar, sempozyumumuzun ikinci oturumu sona ermiştir. Saat 13.30'da başlayacak olan karşılaştırmalı hukukta anayasanın yorumlanması konulu üçüncü oturuma kadar programa ara veriyor. Tüm konuklarımıza çok teşekkür ediyoruz. Değerli konuklar, sempozyumumuzda 3. oturum başlamak üzeredir. Siz
Distinguished guests, the second session of the second day of our symposium is about to start. Would you please be seated? Thank you.
Anayasa Mahkemesi'nin saygıdeğer başkanı, değerli
President of the Constitutional Court, distinguished guests. Now we will have the third session, which is themed as interpretation of the Constitution in comparative law. And the chairperson will be Zühtü Arslan, President of the Constitutional Court. We will have Associate Dr. Saadet Yüksel, Judge of the European Court of Human Rights. We will have Zlatko Knevic, member of the Constitutional Court of Bosnia-Herzegovina, and Eni Nubaginish, a member of the Indonesian Constitutional Court. We will have Jong Seok Lee, a member of the Korean Constitutional Court, and Gert Lübbe-Wolf from Germany.
oturumu başlatmak üzere sözü oturum
And I'll leave the floor to Mr. Zühtü Aslan, the President of the Constitutional Court. Distinguished participants, I salute you all with respect. Of course, the last session of the symposiums are a little bit hard because we are tired, and this is the end of the second day, so we would like to leave as soon as possible. But this is a very important session, which is themed as interpretation of the Constitution in comparative law. We have Korea, Bosnia-Herzegovina, and we have also the Korean court, and they will just talk us about how they interpret the law. And also we will have one judge from the European European Court of Human Rights, and we will have some time to questions and answers. And now I'd like to leave the floor to European Court of Human Rights Judge Dr. Saadet Yüksel. Distinguished President, distinguished guests and participants, I am really honored to be a part of this symposium because I was a part of the Court of Constitution, and this is quite meaningful for me. And I'd like to thank to the President of the Constitutional Court and to all my colleagues in the Court of Constitution. And of course, I hope that they will have many more years to come to celebrate. And of course, the Constitutional Court of Turkey is an example, and we have the accumulation of knowledge from the Ottoman era, and of course, in the 60s, the Court of Constitution was established, but this was not a new idea. It has been discussed in depth prior to that. But I'd like to congratulate the 60th anniversary of the Court of Constitution. And I need to remind that it has been over a century that we have accumulated experience and knowledge, but we have great responsibilities. Court of Constitution has great responsibilities, and we need to talk about human rights and the Constitutional Court, and I will have a different perspective from the perspective of the European Court of Human Rights. And of course, We have distinguished presidents, judges, and academics amongst our participants. But it is, of course, as we have mentioned yesterday, the interpretation of Constitutional Court does not end there. Even from the first degree to the Constitutional Court, of course, there is extrajudicial constitutional interpretation. But there are many parties here interpreting the law, and of course the Strasbourg court has its own interpretation, and of course there is the principle of subsidiarity, and this cannot be. This should be taken into consideration, and of course we need to talk about this principle.
İnsan Hakları Mahkemesi'nin anayasa yorumunu
Of course, the interpretation of Constitution by the European Court of Human Rights is a huge subject. The institutional structure of the Strasbourg Court is different, but it has a different interpretation of law. And of course, within the subsidiarity principle, we have to take into consideration the interpretation of the Strasbourg Court of the constitutions of the member countries. Of course, the Strasbourg Court is different from the national courts. There is a theoretical end. Of course, the Strasbourg Court cannot come to conclusions, theoretical conclusions, because when we talk about the subsidiarity principle, it has been a long time, but I'd like to just dwell upon this principle. Practically speaking, it's much of appreciation, and of course we need to talk about the interpretation of the Strasbourg Court, and also the interpretation of the convention as well. The subsidiarity and the margin of appreciation are quite important here, and of course sometimes we need to check with the internal regulation, with the internal legislation of the countries. And from the 2000s, of course, we are talking about the fundamental rights and liberties of the individuals. So the local authorities during the judiciary process, they need to evaluate all other precedents, and also they need to implement the convention. We have also procedural turn, and we need to. There is a mechanism of control of the procedures. The court, first of all, needs to see the procedural settings of the court which will interpret the convention. And of course, it all started with the 2000s, and there were a series of conferences about the interpretation. There was the Brighton Conference, and there is the Brussels Declaration. The fundamental rights and liberties, whether they are implemented in the national legislation, is the question. Of course, first of all, we need to know the principle, which is the subsidiarity principle. And we see that this principle is at the forefront. And we need to see that the process-based control is quite important, because it is all about the judiciary quality. So what are the main reasons of the ruling of the court? And the national courts, of course, the national courts' verdicts are also interpreted with the texts, with the convention texts. When the court decides and comes up with a ruling, it needs to substitute the national court with the reasons listed. And of course, we need to see the legislature and how the legislation legislated certain laws and how these laws are interpreted. And we are also talking about the rule of law and observation of the rule of law. We are talking about evolutionary change. When we talk about judiciary process, we think about the content, then we just investigate the rulings. And of course, we look at the independence of the judiciary system of the member countries, whether they are dependent or independent, and how the judiciary members, the jurists, whether they are free, whether they have freedom of speech. And we have Gisela versus Poland, and of course we are we have the same controlling mechanism. We have the same investigation mechanism of the ruling of the court. And of course, this was a case related to a Supreme Court member. And when we talk about the 6th article of the convention, the rulings should be in alignment with the rule of law. So we are talking about the judiciary processes, and about the subsidiarity principle. Of course, when do the rulings of the national courts are aligned with the European Court of Human Rights? When they don't align is another matter to be taken into consideration, because interpretation differences are not fixed. Strasbourg is following the rulings of the Constitutional Court. Constitutional Court is also following the rulings of the European Court of Human Rights. So there is an ever-changing relation, and of course this could be also called as communication of interpretation. Sometimes there is memorandum of understanding between the interpretation. And when we talk about the 8th and the 10th article, we could just give you some examples. But there are other examples in terms of individual rights and the violation of the individual rights. So, and about the letters of the inmates Sometimes there is the violation of privacy of the individual rights about the letters of the inmates to the family members. So there are some interpretation similarities, not only the 10th article but the 5th article about the freedom of the individual and the security of the individual and also integrity of the individual. And in many of the cases, the applicant is found right, and if not, they could just go on to apply for the European Court of Human Rights. But in terms of criticism, the institutional interpretation of the Constitution is quite crucial, but the judicial interpretation is another part of it. But there is the general acceptance. Sometimes there is there is the dispute of interpretation in terms of freedom of expression, for instance, and sometimes there is a court case of freedom of expression, and sometimes the verdict is not accepted by the European Court of Human Rights, but the subsidiarity principle is determining the institutional interpretation of the ECHR, and of course this might be aligned with the national courts and the constitutional court, but sometimes there might be a difference of interpretation. Of course, the interpretation has many actors. We have many different organs. This is a natural part of the process, and I'd like to congratulate once again the 60th anniversary of the Court of Constitution, and the capacity of the Constitutional Court is rising, and of course the Court of Constitution is in judicial communication with the other courts of the world. Thank you very much. And we would like to thank Saadet Yüksel because she did not really exceed the time reserved for her, and thank you very much for the conversation. And the second speaker is Zlatko Knežević, member of the Constitutional Court of Bosnia and Herzegovina. You have 10 minutes.
Dear colleagues, I'm only judge, not professor of law, and 10 minutes in my review, it's 10 minutes. So, dear Mr. President, dear colleagues, on behalf of President of Constitutional Court of Bosnia and Herzegovina, Mr. Mate Tadić, who is here, and all judges and employees of Constitutional Court of Bosnia and Herzegovina, please allow me to greet you at today's conference and to address your sincere expression of congratulation of your anniversary. Constitutional Court of Republic of Turkey has a true friend in the judges of Constitutional Court of Bosnia and Herzegovina, and our professional cooperation and relationship provide a successful example of how collaboration and friendship should be developed and advanced. Thank you one more. In due respect time, today I explained several theses, full text edited in the Constitutional Court of Turkey. In terms of history and issue of transition for a socialist system, Bosnia and Herzegovina provide a rare example of a country in transition from a socialist system. Nevertheless, it has a history of having a constitutional court, since in the former Yugoslavia was the only country which had a system of constitutional courts already in socialist regime. The first constitutional court in former Yugoslavia was created as early as 1963, and that date coincided the starting point of the history of constitutional judiciary in this country. Lucky coincidence, Constitutional Court of Turkey today is 60 years anniversary. We are in 2024 having 16 years. Constitution of Bosnia and Herzegovina, Annex 4 of General Framework Agreement to Peace in Bosnia and Herzegovina, now provides the legal framework for organization and function of the Constitutional Court. In addition to the Constitution, European Convention for the Protection of Human Rights and Fundamental Freedoms applies directly in Bosnia and Herzegovina like constitutional norm, as has priority over all other law. So, relationship between the jurisdiction of the Constitutional Court and other courts in Bosnia and Herzegovina. Given the provisions of Article 6.3 of Constitution of Bosnia and Herzegovina, we could say that the relationship between the Constitutional Court and other courts are establishment or two bases. First one is appellate jurisdiction over issues under the Constitution arising out of a judgment of any other court in Bosnia and Herzegovina. It makes the Constitutional Court the highest institutional guarantor of protection of human rights and the fundamental freedoms under the Constitution and European Convention. Appellate jurisdiction of Constitutional Court under Article 6 does not mean that the Constitutional Court has jurisdiction to act as a court of fourth instance and review the same complaints as those dealt with by the previous instance. Quite the contrary, within the scope on the appellate jurisdiction, Constitutional Court deals exclusively with the issue of alleged violations of constitutional rights or rights under the European Convention. Every person under the jurisdiction of Bosnia and Herzegovina is entitled to file an appeal to seek protection of his or her constitutional rights and freedoms, provided that he or she meets the prescribed formal requirements. In addition to natural person, the protection may be requested by legal person and governmental authorities because the protection ratio personae, as interpreted differently when compared to European Court and the state of Bosnia and Herzegovina, but also its entities and cantons may request protection on their constitutional rights before the constitutional courts. You know, Bosnia and Herzegovina have very, very complicated constitutional structure, 2 cantons, 1 district, 2 entities, 1 district, 10 cantons, state level and others. But after my friend, Ministry of Justice Lebanon, I say him in Bosnia and Herzegovina, very complicated situation, 3 ethnics, 3 religions and others, he say complicated. We in Lebanon have 18, and after that, Bosnia and Herzegovina very simply. So, it should be noted that all these cases are considered in terms of constitutional rights, not rights under the European Convention. And for example, constitutional law protecting and constitutional rights and freedoms, including catalogue of human rights in Constitution of Bosnia and Herzegovina and European Convention, which has a special place in Constitution in Bosnia and Herzegovina. International standards. Rights and freedoms referred to European Convention apply directly in Bosnia and Herzegovina. These have priority over all other law, like in one question in last session, directly and have a priority all over law, including international treaties. Annex 1 to the Constitution of Bosnia and Herzegovina, which consists of 15 international instruments for the protection of human rights and freedoms. For conclusion, European Convention in integral part, our Convention, and in Annex 1, 15 international instruments, like in political rights, rights for children, and others. In fact, that the Constitutional Court of Bosnia and Herzegovina is the only constitutional court of the level of Bosnia and Herzegovina has a special impact on the task and jurisdiction of the Constitutional Court. Theoretical models of interpretation, constitutionality, and protecting human rights and freedoms, you know, pure Kelsian model in Constitutional Court is at the same time a model of review of constitutionality. In the pure model, there is a constitution which the final acts and others, and only applied in the interpretation of its norms. But one of the key views that has become the standard, it's a reality long establishment conclusion of European Court. In the case of Tyler with United Kingdom. Establishment, next sentence. Convention is a living instrument which must be interpreted in the light of the present day conditions. It's in 1968, and now actually it's very, very true. Therefore, theological approach in use today in the praxis of all constitutional courts, we're interpreting a constitutional norm in relation of the norms European Convention. It's especially a question, it's not in this topic, in this symposium, it's a relation with supranational law, supranational constitutional law, and supranational courts, and relation with national law, national constitution, and national high-level courts, constitutional courts. I think in European Court, European Convention, European Court, Convention, Constitution of Bosnia and Herzegovina, and Constitutional Court of Bosnia and Herzegovina, and like in Turkey. It's a very important and very complicated question. We know situation in Europe now, it's like in a member of the Venice Commission, I know many situations, or a Russian who is changing the constitution in impact case law on European Convention, having problem with Poland, having problem in Hungary, German federal constitution and federal constitutional court is some situation different and others. So, we also stress a reaction to European Court or the German Federal Constitutional Court, which their decision, some important decision, directly influence to reaction of the legislator. It's a very, very complicated situation, but however, this practice has become general with various forms of action of the constitutional and judiciary towards of legislature. Some legal principles, legal standards, abstract type of best practice, and special norm on law throughout the world are therefore only a source of law in the substantive and not in the formal sense. Not in formal sense. Therefore, for the reasons already mentioned, it is necessary briefly to review the application impact of decision of European Court in relation to national law and constitutionality when it comes to the protection of fundamental rights and freedoms. And for conclusion, dear colleagues, I did not engage in discussion of the contribution of the classical review of constitutionality in terms of the protection on fundamental rights and freedoms. Above all, National Constitutional Court always has a task where reviewing the constitutionality of the particular law to review in compliance with the constitution of country, as well with international documents that are either an integral part of the national constitutional order or are superior to national legislation. Therefore, this decision is always related to one term of international law. One term of international law within the national context and represents a general review of constitutionality for a given state, but also a consequence for individual who benefits from such a review. Thank you. Attention, 10 minutes, Mr. President.
We would like to thank Mr. Knežević because he just shared his experience from Bosnia-Herzegovina, and now Enin Nurbaningsi from Indonesia. You have only 10 minutes. Thank you very much.
Press my presentation. Assalamualaikum warahmatullahi wabarakatuh. Distinguished speaker and delegations. In this good occasion, I would like to give a presentation on the Indonesian Constitutional Court interpretation of the constitution related to the protection of fundamental rights and freedoms. The idea of a democratic state based on the rule of law should be seen from the perspective of the protection of fundamental rights and freedoms as guaranteed by the Constitution. The idea to include human rights in the Indonesian Constitution was discussed by the framers of the Constitution 1945. The Indonesian Constitution was amended 4 times from 1990 to 2002. The second amendment in 2002 guarantees human rights, which are outlined specifically in Chapter 10A on human rights from Article 20XA to Article 20XG. This constitutional provision assures human dignity, to right to equality, personal liberty, civil and political rights, social economic rights, and other important fundamental rights and freedoms. These constitutional rights are not only influenced by the Universal Declaration of Human Rights, but also by various international convention and international law instruments. The constitutional safeguards have had a significant impact on the development of constitutional democracy in Indonesia today. In addition, the protection of human rights and its implementation is further regulated in Law Number 39 of 1990 on human rights and other legislation, guaranteeing the recognition and respect of citizen rights and freedom based on morality, religious values, security, and public order in a democratic society. All of these constitutional and legal instruments guarantee fundamental rights and freedoms for everyone without discrimination. The consequence is that the government is obliged to respect, protect, implement, and advance the human rights contained in the Constitution and laws. One of the efforts to protect fundamental rights has been the establishment of the Constitutional Court of Indonesia, which was initiated by the process of political change from authoritarian power to constitutional democracy. It is in line with the momentum of the constitutional amendments during the reform era. The third constitutional amendment of 2001 provided for the creation of a constitutional court, which was duly established in 2003. The Constitutional Court of Indonesia is one of the state institutions exercising independence, judicial powers in administering the judicial system with the aim of enforcing law and justice. The Constitutional Court has 5 authorities as set forth in Article 24, paragraph 1 and 2 of the Constitution. Based on its power and authorities, the Constitutional Court essentially functions as a guardian of the Indonesian Constitution, democracy, fundamental rights, and freedoms. Whenever there are laws that are repressing or denying the citizens' rights, then based on request by the people, the Constitutional Court can play its role to protect, to promote, and to rehabilitate the constitutional rights of the citizen from such suppressions. The Constitutional Court's decision is final and binding, so the Constitutional Court also functions as the final interpreter of the Constitution. When exercising its power to review the constitutionality of laws, the Constitutional Court must interpret the Constitution by following textual and contextual dynamics. Based on Article 5, Paragraph 1 of the Laws Number 48, 2009 on judicial power, stipulate that judge and constitutional judge must explore, follow, and understand the legal values and a sense of justice that lives in society. The standard for determining the constitutionality of laws must be the text of the Constitution, which means the Constitutional Court use one of the original intent methods for interpreting the Constitution. The original intent protects the original ideas and enthusiasm during the formulation of the constitutions and laws. Ladies and gentlemen, since its establishment in 2003, the Constitutional Court of Indonesia has decided important cases on the protection of fundamental rights and freedom, which can be seen in its landmark decision. One of the important decisions of the Constitutional Court concerns the protection of freedom of religion. In the Native Faith Followers case, 2017, the judicial review case was filed in 2016 by followers of 4 indigenous faiths who was argued that the law violated the principle of equality before the law. In this case, the court considers that the dispute article provided no legal certainty and violated the principle of equal justice for all citizens, which contradicted the Indonesian Constitution. The Constitutional Court warranted a judicial review of Law Number 24 of 2013 on civil administration law, allowing Indonesian native faith followers to have their belief officially recognized by the governments. Another interesting landmark decision can be found in the case of freedom of speech. For example, in the Lese Majesty case, 2006, which involved a political activist and a lawyer prosecuted for insulting presidents. In deciding the case, the Constitutional Court found that the criminal court articles organized from Dutch colonial rule, known as hate-sowing articles, which were designed to safeguard the royal family and colonialists from opinion and criticism by citizens. The Constitutional Court concluded that the article violated the Constitution. Through this decision, the court protects the right to freedom of speech by keeping state institutions transparent and responsive to public opinion and criticism. Another example is a case on the right to vote in election 2019. This case was submitted by a number of democratic activists who argued that many citizens could not exercise their constitutional rights to participate in election because they do not have an electoral ID card. In deciding this case, the Constitutional Court said that the minimum requirement for voters to be able to exercise their right to vote is to have an electoral ID card in accordance with the population administration law. However, if there are citizens who have the right to vote but don't have an electronic ID card, the court allowed them to vote in the general election by using a recommendation certificate issued by the Population and Civil Registry Office as a proof they had registered their data. Based on these constitutional cases, the Indonesian Constitutional Court has become one of the main actors in the protection of fundamental rights and freedoms. In the case of freedom of religion, freedom of speech, and the right to vote in election, the Constitutional Court has made strong constitutional interpretation related to the development of democracy in Indonesia. Ladies and gentlemen, summarizing the above, I would like to note that the constitutional interpretation by the Constitutional Court is important for the protection of fundamental rights and freedom in Indonesia. As I come to the end of my presentation, I hope the good relation and cooperation that have been established between countries and fellow of the Constitutional Court and equivalent institutions shall continue to establish and improve in the future. Finally, I would like to congratulate to Turkish Constitutional Court on celebrating its 60th anniversary, may be coming years achieve even greater success. Thank you very much for your attention.
Evet, biz de Yargıç Nurbaningsi'ye çok
We would like to thank you, Madam Justice. You have a perfect timing. And the final speaker of this session, Justice Lee from South Korean Constitutional Court. You have...
Excellencies, my name is Jong-seok Lee, and I serve as Justice at the Constitution Court of Korea. First and foremost, I would like to offer my sincere congratulations on the 60th anniversary of the Constitutional Court of Turkey. It is my great pleasure to be in this valuable occasion with distinguished colleagues and guests across the globe to share my experiences and thoughts on constitutional education. Taking this opportunity, I would like to summarize my paper within the time allocated for my presentation. Exploring the meaning of Constitution is a precondition to applying the Constitution. Constitutional interpretation is the initial step as well as the basis for constitutional adjudication. The Constitution speaks of wide-ranging matters compared with other legal norms. However, it provides only a limited number of provisions to cover these matters. Consequently, constitutional interpretation plays an important and influential role. There have been extensive discussions and suggestions as to the modes of constitutional interpretation in the Republic of Korea. The generally accepted view is that while a constitutional provision should be interpreted based on the plain meaning of each text, other considerations such as its correlation with the other constitutional provisions and the entire Constitution, the purpose of constitutional law, the intent of the framers of the Constitution, and the historical background of the Constitution need to be factored in as well. Still, in applying such modes of interpretation, answers to the question of setting the priority among different modes and managing the modes in conflict have not been clearly established. In the next part of my presentation, let me introduce two decisions by the Constitutional Court where we can take a glimpse of the court's way of interpreting the Constitution. The first case relates to a legal provision that prescribes detention in a guardhouse as a disciplinary measure to people in military service. The Constitutional Court held the legal provision unconstitutional on the grounds that the detention goes beyond its scope as a disciplinary action by depriving the people of their bodily freedom, and thereby violates the rule against excessive restriction. However, as to whether the legal provision has violated the warrant requirement, justices were divided in their interpretation of the Constitution. 4 justices all find that the legal provision runs contrary to the warrant requirement, According to constitutional interpretation of these four justices, bodily freedom is a basic right that is not only protected at the stages of criminal proceedings. When considering the plain meaning of Article 12, Section 1 of the Constitution and the nature of bodily freedom as a natural right. On the other hand, two justices viewed that the legal provision does not run contrary to the warrant requirement. The two justices interpreted that as long as a constitutional provision is clearly applicable to criminal proceedings only, after considering its plain meaning or the particular way of guaranteeing bodily freedom, the constitutional provision is exclusively applicable to criminal proceedings. This case is viewed to have portrayed the divided views over whether to put emphasis on the purpose of constitutional law or on its structure and plain meaning in the course of interpreting the Constitution. The second case relates to acknowledging foreigners as the subject of fundamental rights. The Korean Constitution enumerates fundamental rights in Chapter 2 under the title Rights and Duties of Citizens. The chapter prescribes citizens as the subject of fundamental rights provided by the Constitution, and legislative documents made in times of drafting the founding Constitution reveal that the intention behind using the expression citizens, not the people, was to deny foreigners as the subject of fundamental rights. However, in circumstances where a type of fundamental right is beyond the right of a citizen and could be regarded as that of a human being, the Constitutional Court acknowledged foreigners as the subject of fundamental rights. Notwithstanding the possible conflict with constitutional texts and intents of the framers of the Constitution, the Constitutional Court has broadened the subject of fundamental rights in reflection of the purpose of constitutional law and the respect for international law. In this case, where a foreigner filed a suit to annul the decision to deny his or her entry into Korea, the criminal court acknowledged foreigners as the subject of the right to receive assistance of counsel and confirmed unconstitutionality of the refusal to allow attorney visitation. As illustrated throughout this presentation, the Constitutional Court of Korea interprets a constitutional provision based on the plain meaning of the text, while taking into account several factors such as its correlation with the overall structure of the Constitution and other constitutional provisions and the purpose of constitutional law. On a separate note, the importance of comparative law cannot be overlooked when interpreting the Constitution. Owing to the recent trend of the universality of constitutional law and spirit, growing similarities in the practice of constitutional adjudication, and active exchange of ideas, between constitutional adjudicatory institutions across the world. The significance of comparative legal analysis is ever growing. On this account, I hope that this highly valued conference will serve as a cornerstone for constitutional adjudicatory institutions from all over the world to actively engage with one another and exchange experiences about constitutional interpretation. Thank you very much for your attention. Thank you.
Evet, biz de yargıç
We would like to thank Mr. Lee. You have delivered your speech right in 10 minutes, which allows us another 10 minutes for questions and answers. Now, if you have any question to our speakers in the panel, please feel free. Yes, please, Mr. Murat. Please first introduce yourself and also please indicate who you ask your question. I am a rapporteur at the Constitutional Court. I would like to extend my gratitude to distinguished panel for their presentations. My question is to the Associate Professor Saadet Yüksel. Maybe it is a specific question. The discretion the European Court of Human Rights concluded that Constitutional Court of the Republic of Turkey is a domestic remedy which requires to be exhausted. Yes, but the Turkish Constitutional Court does not have the authority to look at some cases, like the decisions of the Supreme Board of Elections. And when there is an application to the Constitutional Court about this kind of things, inadmissibility is the decision. But when we look at the decisions of the European Court of Human Rights, the European Court of Human Rights still sees the Turkish Constitutional Court as a domestic remedy that needs to be exhausted before going to the European Court of Human Rights. So my question is, can we take some cases directly to the European Court of Human Rights without bringing them in front of the Turkish Constitutional Court, or can they view the cases in the European Court of Human Rights this way? Thank you. It's a very specific question, Murat Bey, but of course I will give a general answer because these topics are very general topics. I will try to point out two general issues. The second, the subsidiarity principle, I just mentioned it in one single sentence, but here I will try to explain it more. Subsidiary principle is the appreciation margin doctrine of the court. So it's not only a mere expression. According to this doctrine, we say that the proportionality and necessity to make intervention in rights and liberties, the national authorities are in an advantageous position vis-à-vis the European Court of Human Rights, which means actually European Court of Human Rights is self-restricting itself. But it does not mean that they never look at these cases, they never view these cases. So in one single sentence in my presentation I said that there is subsidiarity principle and the appreciation margin doctrine. This does not reduce the power of the Strasbourg court. So it does not prevent the European Court of Human Rights to view how the national court looks at the case, because it defines it. I talked about the traditional case law before 2010. It is a much more substance-based review, and after 2010, the process-based view started to be dominating. But very recently, the third part is the rule of law-based view. So we are concentrating on the rule of law based view nowadays. But it does not mean that we have left the first two ones. There are interactions here. So when we talk about rule of law based view, we see that this appreciation margin is being interpreted on a more narrow basis. Mr. Jai talked about this actually. The appreciation margin in extraordinary times, versus Hungary, versus Poland. There are some cases versus Turkey as well, and the appreciation margin doctrine was interpreted on a more narrow basis when there are extraordinary situations. So, as you have said, going to the Strasbourg court by exhausting all the remedies in Turkey, but it is also an indicator showing us that the European Court of Human Rights is a subsidiary court. It's about the subsidiarity principle. So, if the applicant can put it forward, sometimes we can see that the Strasbourg court can step in. But as we said, in general, Constitutional Court of the Republic of Turkey is the most important domestic legal remedy before going to the European Court of Human Rights. Thank you.
Orta sıradaki hanımefendi, mikrofonu uzatalım.
There's a lady out there. Please pass her the microphone.
Dear colleagues, I would like to thank all of you for your very inspiring and interesting presentation. I think that all of you be able to answer my question, which is about collegiality. Collegiality used to be assumed, but not. I think that collegiality is the vital to judicial function, and we are all judges. We are members of collective judicial bodies. We are not judges sitting alone. So I think that as one American judge said that we should balance one another. So we are not politicians. We should not be popular, but we try to render, to get our decision as much as just as it possible. So I would like to hear from you about this. I think very, very interesting and very important topic in our mission.
Okay. Zlatko Bey?
Maybe Judge Yüksel, she's in high level on me. I'm just Constitutional Court judge, not European Court. You know, Ingrid, so all judges in the world, especially in Europe, especially in the constitutional courts, having two problems. First problem, before elected, our professional life, our professional past situation and others. After elected, the second problem, all public relation, media, TV, politicians have a task to influence to us decisions, judgment, and statements. I say not to Weasley, but my personal reason. Influence, maybe yes, but impact in decisions, judgments, and statements, not. It's my modestly answer.
Teşekkür ederiz.
Thank you very much. Is there any other question? İlhan Bey, the final question, please. The very last one.
Teşekkür ederim başkanım. Muharrem İlhan Koç.
Thank you very much. I'm reporter of the Constitutional Court. And with the inspiration from the previous session, I would like to say something about this session too. We are generally focusing on the European Convention on Human Rights and the European Court of Human Rights, but this is also something related to the Turkey, other international organs or constitutional courts. ECHR takes the state party as a whole, and it makes some assessments and evaluations and examinations. There were some violation decisions by the ECHR for Turkey, but Constitutional Court has some limitations in terms of its authorities and duties. As mentioned before, constitution provisions, there are the constitution provisions on one side, and there is also international conventions, international agreements, and the conventions are not limited, and they work in a different process. And in international processes and international organs, there are different approaches, and constitutional and contractual processes are different, and there is a problem in this regard. How can we resolve this issue, do you think? I would like to hear your opinion. Yüksel.
Soru aslında sorudan öte biraz katkı gibi. Sadece genel olarak.
Actually, I tried to give the answer to this question in all my presentation. It was my main objective, but probably I wasn't able to give the answer. Maybe I can talk about the general principle again. You are talking about some conflict or what? Actually, we don't have such a problem. Of course, there are different interpretations, and I gave some examples of differences in interpretations, and I used this in my presentation. In some cases, we have some similar interpretations. In some other cases, we have different interpretations. And in some decisions about freedom of speech, expression, for example, there are some examples. But you're talking about this on a general term. And actually, what you're trying to say is the convention system itself, I think. In the interpretation of the convention, the Strasbourg court is important, and its decisions are binding, and we have the subsidiarity principle there. And sometimes, and especially after 2010, we worked together with Supreme Courts of the member countries, member states, and we also checked the interpretations of the Supreme Courts of the member states. The convention, as can be seen in its first article, provide gives some liabilities, responsibilities to the member country in terms of protecting the provisions of the convention. There are some relations between the Supreme Courts and the Strasbourg Court, and especially after 2010. We have a cooperation. We are working together. When we think about the Supreme Courts, we are talking about day-to-day responsibility here. The states, member states should find a resolution about the violations of rights and freedoms, and then they should come to the Strasbourg court, and then it is resolved. And I think this is what you tried to mean, but I can say that subsidiarity principle is important here. And relations, communication with the member states are really important. We're talking about the shared responsibility. Since 2010, all countries are saying that Strasbourg Court and Supreme Courts and their relations and cooperation are really important. But I would like to repeat that it is really important to interpret the law, but of course we cannot always have the same interpretation. Thank you very much. This is the end of our symposium, but I would like to take a few minutes of you, and I want to say something about this interpretation issue. And all courts are councils of interpretation. Constitutional courts are quite visibly courts of interpretation. So this interpretation of these courts are really important. It is not just the case for the constitutional courts, it is also the case for the criminal courts. And it might be a matter of life and death in some court cases. This interpretation is really important. When we think about the faith, interpretation is also important. When we look at the holy books and their interpretation, we can have wars, and in the history this happened, and also world wars happened because different interpretations. There's some texts, whether they are secular texts or holy texts, we are generally having these issues in our interpretations of these texts. One of the greatest texts is the Venice, Merchant of Venice from Shakespeare. And actually, Shakespeare tells us how it will end in a tragicomic way. There is a man, he is Jewish merchant, he loans money to a person for 3 months, and they make an agreement. If you do not pay, he said that if you do not pay this debt, we will have 1 pound of meat from your body, which is at a place which is very close to your heart. It is about 5 gram, actually 450 grams. Sorry. So they say that if you do not pay the money, they will get this meat from his heart. He is not able to pay the money. He is also a merchant, and this Charlotte says that I will take this money, or I will get this meat from you. And then the indebted files a court case, and he says that this cannot be interpreted in this way. And there is a court, there is a hearing. They bring knives, and they prepare the knives. And the indebted says that please interpret this law once, and please emancipate me from this evil man. And the judge says, in Venice, laws are really important. Nothing prevails laws. We will do what the law stipulates. And then hearing starts. The lawyer of the indebted says that, okay, you're not forgiving this person, and this is my interpretation. Then, what does what the agreement reads? It says 450 grams of meat. But it does not include blood. It's just meat. If you have 1 drop of blood when you are cutting this meat, you will be fined, because you will you will cause the loss of a blood for the person, and he also says that when you are cutting, if you cut more than 10 pounds, even slightly, then the fine for this is death. So it should not be 1 gram less or each 1 gram more. So they say that, okay, get the knife and cut your meat. And he says that, okay, I will not. I don't want to have this meat. Please give me my money back. But he says that no. And then he says, okay, then I will leave. I don't want anything from you. But they say, no, you cannot go, because Venice laws stipulates that if you threaten the life of a person, you will be fined. So you tried to take a part of a person. You want the meat of a person, and the fine for this is to give your properties, half of your properties, to the victim. But of course, the victim can say that I forgive you, but he says that I have 2 conditions. He will turn to Christianity, and properties, half of the properties will be given to his son-in-law. So, interpretation is a matter of life and death. Sometimes it saves the life, sometimes it ends the life. So, the history of people is based on interpretation, and since the Greeks, antique Greeks, this is a part of life, and of course in law this is a significant issue, and we cannot of course discuss such a deep issue in just 3 sessions, but we try to draw a certain general framework with the sessions we held yesterday and today. I want to thank all the speakers of this session and the members of the Constitutional Court and our judge from the European Court of Human Rights. I would like to thank you very much for your patience. You listened to our presentations, you asked questions, you made comments. Thank you very much. I wish you a healthy, peaceful day. We would like to thank Zühtü Arslan and the panelists. Our president will present plaque to the participants of the session.
Evet. Benden başka kimse çevirmemiş.
Sayın Başkanım, değerli konuklar, sempozyumumuzun kapanış konuşması.
So, esteemed distinguished President, distinguished participants, now I would like to invite Kadir Özkaya, Deputy Chairman of the Constitutional Court, to deliver the closing speech of our meeting.
Sayın Başkanım,
His Excellency, Mr. President, Presidents of the Constitutional Court, distinguished representatives, distinguished colleagues, I am really honored to address to such an august gathering. But we have a flight to catch at 11:15. So I think the best closing speech is to keep it short. This is the 60th anniversary, and I'd like to thank you for being with us to celebrate the 60th anniversary. I'd like to greet and extend my best regards to Bukiko. I'd like to thank them once again, and I salute you all with respect, and I wish you a safe flight to Istanbul. Thank you very much.
Sayın Başkanım, değerli konuklar, Anayasa Mahkemesi'nin 60. kuruluş yıl dönümü etkinlikleri kapsamında
And we had a two-day symposium on the protection of the fundamental rights and liberties, and we have come to the end of the symposium. Thank you very much for your patience and wish you a good day. Thank you very much.